I'm Spencer Mazyck, and joining me now is Paolo Di Rosa. He is the head of the International Arbitration practice at Arnold Porter, who represents the Republic of Colombia in a dispute with a U.S. salvage company over possibly the most valuable shipwreck ever discovered, with some estimates putting the value of the sunken treasure in excess of $17 billion. Welcome, Paolo. Thank you for joining us today.
Thank you for having me.
So first, let's talk about this sunken treasure aboard the San Jose. Can you tell us how and when did the shipwreck occur?
Well, the ship was sunk in a naval battle with the British Navy. This was a Spanish warship that was transporting what's estimated to be several $1 billion worth of gold and other precious metals. And at the time, Spain was at war with Britain. It was part of the War of Spanish Succession in the early 1700s, and on June 8th, 1708, the ship was near the coast of what is now Colombia, and the British Navy sunk it in a very famous battle.
So it was more than 300 years ago, and according to some reports, you mentioned that there are precious metals there, but some reports say that there are 2 tons of platinum along with significant amounts of gold and emeralds. But, I mean, do we really know what's there?
No, not really. Apparently the manifests that were recorded and that showed the contents of the ship have been lost, and so nobody really knows the specific contents of the ship. It is known that it was laden with coins and other precious metals, but nobody really knows for sure. The ship has been at the bottom of the sea for 305 years, and it's at a depth of between 700 feet and 1,000 feet, so nobody's really seen it. You know, this dispute is in part over the claim by this company, Sea Search Armada, that they have located the ship. We have no evidence that that's true.
Oh, wow. So was it around, though, 1980 when the Colombian government authorized a company called Glocamora to explore its coast for shipwrecks and sunken treasure?
That's right. In 1980, the Colombian government did authorize this company, Glocamora, to search for ships generally off the coast of Colombia and the Caribbean. After that, the facts get a little bit fuzzy because this company, Sea Search Armada, claims that they were assigned the rights that were given to this Glocamora company, but we have seen no evidence of that. And,
yeah, in fact, Sea Search Armada says that they were, it is unclear whether or not Glocamora was even entitled to 35% or 50% of the treasure, but Sea Search Armada says that they were assigned whatever rights Glocamora had in the treasure in around 1984.
Correct. The figure that they cite has varied. And first they said 35%, then 50%. The fact is that even though they claim that they had a contractual relationship with the government of Colombia, they never actually produced a contract. So we don't believe that they have any rights really that they have been able to prove, at least in the proceedings in the U.S.
Was there also a law, though, passed shortly in Colombia regarding the treasure at some point after all of this?
Well, there was a law that was passed in 1984 which essentially said that any treasure that was found would be owned 95% by the government of Colombia, and a 5% finder's fee would go to the salvage company. That law was subsequently overturned after a lot of litigation over the course of 2 decades by Sea Search Armada and the Colombian courts.
So despite winning in the Colombian court, Sea Search Armada now alleges that the Colombian government has threatened to use military force against its team if it tries to recover this treasure. So then it filed an action here in the U.S. in 2010 claiming what?
Well, let me just clarify that point because it's important. The issue of the use of force by the Colombian government against Sea Search Armada is a slight distortion. What happened there was that Sea Search Armada said that after it was refused access to the site of the ship, they said that they were going to unilaterally go and rescue the ship, and that's ship is in Colombian sovereign waters, and of course the Colombian government has the responsibility to protect that site, so they indicated that they would not allow any unilateral efforts by this company to accede to the site.
So are you saying though that the Colombian government would be okay if Sea Search Armada did it jointly with them, made a joint effort to rescue the ship?
Well, if the Colombian government, in its sovereign power, were to decide to do it jointly with this company or any other company, of course they could do that. The issue is really just that Sea Search Armada is not permitted to just go out there and rescue this ship, which is ultimately archaeological, historical, and cultural patrimony of Colombia.
Well, so can you bring us back to present day? They filed an action in 2010, and what were the allegations in their complaint?
Well, they sued here in the federal court here in Washington, claiming essentially three things. First, breach of contract. And to show a breach of contract, you have to produce a contract. Obviously, there was no contract here. They did not present any contract in any stage of the proceedings in the U.S. They also claimed conversion, which is essentially a tort claim for misappropriation of property. They claimed ownership of this property by virtue of the rights that were conferred by this alleged contract, which they did not produce. And finally, they wanted recognition by the U.S. courts of a Colombian Supreme Court judgment that was issued in 2007. And
what did the lower court find here? Because I understand that you guys, is this when you actually started representing the Republic of Colombia in this case?
Yeah, well, before the district court, what we said is essentially, look, the court doesn't really need to get itself into the weeds of what happened with this alleged contract 30 years ago, because the court has no jurisdiction. Essentially, you can't sue sovereign states in the U.S. courts unless they were engaged in commercial activity, which Colombia was not. This is essentially a sovereign act of whether to rescue or not a ship of historical value. And we also argued that the claim was too late. There's a statute of limitations under D.C. law that requires that any claim for breach of contract or conversion be brought within 3 years of when the cause of action accrued, when you first could have brought the suit. And they decided 25 years ago to sue in Colombian courts. They could have done so here if they had wanted to, but they didn't. And ultimately, the court agreed with us on that point. They said that the claim here was brought too late, and we also had argued that the Colombian Supreme Court judgment of 2007 couldn't be given recognition under the D.C. statute that was invoked by the claimants, because the actual decision in that Supreme Court ruling was not to confer a specific sum of money to this company, which is a requirement of the D.C. law.
So the court essentially said that the Colombian Supreme Court judgment decision wasn't a foreign money judgment under D.C. law.
Correct. That's exactly right.
So I do want to ask, though, that obviously this month in April, the Court of Appeals agreed with the lower court here and upheld the decision, but neither court actually addressed whether or not Sea Search Armada has a legitimate right to 50% of whatever treasure is eventually recovered. So to be clear, where does your client stand on that issue?
Yeah, we didn't ultimately get into the merits of the dispute in this case, because it was decided on these grounds of statute of limitations and inappropriateness of recognizing the Supreme Court judgment in the U.S. courts. So we didn't actually address those issues because essentially what we said is, look, even if you accept, for the sake of argument, that what Sea Search Armada is saying is true, that they have rights to 50% of the treasure, they still can't bring that claim here in the U.S. courts. And because the district court granted our motion to dismiss, which was then upheld by the appeals court, we actually never had opportunity to get into the merits issues of ownership and what happened exactly 30 years ago in the context of these alleged contract negotiations.
And just one quick question, when would you say that the breach occurred? Would you say the breach occurred when there was a law passed in Colombia preventing them from actually getting the treasure?
Well, we argue that the claim accrued at the time that the Colombian government first asserted ownership over the entirety of the treasure, which was in 1984. It was at that point that, you know, to the extent that they wished to bring a claim of breach of contract, to the extent that they believed that they had one, they needed to bring it here in the U.S. In 1987 at the latest, which is 3 years after the cause of action accrued. And there's a 3-year statute of limitations both for breach of contract and conversion under D.C. law.
And 1984 is also when Sea Search Armada alleges that Glocamora assigned them the rights to whatever treasure is out there.
Well, it's not clear. I think I've seen in their papers references to an assignment of right sometime between 1980 and 1984, maybe 82, 83. Again, we didn't actually get into the details of that because it proved unnecessary in the end to address the merits.
So as you know, Paolo, this fight for the sunken treasure is not over. Sea Search Armada has recently filed human rights claims against the Colombian government. Do you know what the allegations are there?
Well, we haven't seen a formal copy of this complaint because the Colombian government has not yet received it, but the company has circulated a copy of what they say is the complaint, and I have read that. In essence, they are claiming violations of the American Convention on Human Rights by the government of Colombia. The American Convention is a multilateral treaty on human rights to which most of the countries in the Americas are a party. And specifically, they argue that they were deprived of property without fair compensation and that they were denied judicial protection in Colombia. And so, you know, our view is that this is really just kind of a desperate last-ditch effort to get some court somewhere to hear their claim. The American Convention also has a statute of limitations that's even shorter, 6 months, than the D.C. one. So we think, you know, among other reasons, that probably won't prosper there either.
I have to say that this case to me sounds like a movie or a novel. I mean, can you tell us, though, how did you come to represent the Republic of Colombia here?
Well, just an interesting detail since you mentioned novels. This incident of the sinking of the San Jose off the coast of Colombia in 1708 was narrated in some detail in Garcia Marquez's novel Love in the Time of Cholera, and he addresses it in some detail there. And it's, you know, it's studied broadly in Colombian law schools and such. So it's a, you know, it's a very well-known incident there. Our representation of Colombia came about as a result of an invitation to bid, which is a fairly common way that sovereign states retain counsel in international litigation and arbitration. Essentially, they have a bidding process where a number of firms present proposals, and they select the firm that they think is best situated to handle the matter. In our particular case, Arnold Porter had been representing for many years the government of Colombia in the sovereign finance space, bond issuances and the like, and so, you know, we did have a relationship with the government of Colombia already, but for this particular matter, we were selected after a bidding contest.
Well, thank you for joining us today to talk about this fascinating story about shipwrecks and sunken treasure. We really appreciate it.
No, thank you for inviting me.
For more information on this or other topics, subscribe to BloombergLaw.com. You can follow us on Facebook and Twitter. Thank you for joining us. Bye, everybody.